Also, he'll look at the 2/3 vote required by the legislature to raise taxes, and he has a little spat with the feds over savings bonds that actually is something that most people don't even know about. I don't know if you've seen his political ads, John Neely Kennedy. I didn't know you were from Zachary.
Yeah.
That's a good thing. He's a local boy made good. So let me bring John Kennedy up. Again, the rules of the press club, working press, and only members of the press club can ask questions when we open up toward the end of his talk. John Kennedy.
Thank you, Michael. How many of you remember the Andy Griffith Show? Mayberry was such a peaceful and happy place. I still watch the show. I'm sure many of you do too. I'm very happily married, as some of you know, but did you ever notice that nobody in Mayberry was married? I mean, think about it. Andy wasn't married. Barney wasn't married. Aunt Bee wasn't married. Opie was too young to be married. Thelma Lou wasn't married. Helen wasn't married. Gomer wasn't married. Goober wasn't married. Floyd wasn't married. The only person that I remember who was married was Otis, and he stayed drunk all the time. That's got nothing to do with what I want to talk about, but I thought that was interesting. I read that somewhere. I want to talk a few minutes about the legislative session and the tax issues that are before us. I'll try to touch on the other topics Michael talked about it and mentioned if we got time, but I don't want to run over, and I'm going to leave plenty of time for questions. As you know, the legislature passed about $827 million, by my count, in taxes and fees. About $390 million of that, let's round it off and call it $400 million, was passed without a 2/3 vote. If you look at House Bill 629, House Bill 624, House Bill 805, HCR 8, House Bill 93, House Bill 829, I think if you run the numbers, it comes out to about $389.7 million that did not receive a majority vote of either the House or the Senate or both. Article 7, Section 2 of our Constitution, the Louisiana Constitution of 1974, I think is pretty straightforward. I don't like to read things, but I think in this juncture, I think it might be helpful. This is Article 7, Section 2. The levy of a new tax, an increase in existing tax, or a repeal of an existing tax exemption shall require the enactment of law by 2/3 of the elected members of each house of the legislature. That has been the law in Louisiana for almost a century. It's not only in the 1974 Constitution, it was also in the 1921 Constitution, and the notes to the 1974 Constitution make it clear that the 74 Constitution was intended to continue the law under the 1921 Constitution. Now, as you know, the legislature received advice on which it acted that our 2/3 vote was not necessary in some instances. The business community, more specifically the Louisiana Chemical Association, has filed suit challenging at least one of those acts of the legislature, HCR 8. There will probably be other lawsuits filed, depending upon how well the initial suit goes. Normally, what happens when you contest the constitutionality of a tax statute, The companies doing it, or the individuals, will do what they call pay under protest. That means they pay the money to the Department of Revenue, and the Department of Revenue escrows that money, so in case the Department of Revenue loses the litigation, the money will be there to pay back to the taxpayer. The division of, or rather the Department of Revenue has decided in this instance not to do that. They waived the payment over protest. They're going to take the money and spend it. Ultimately, if the business community prevails, the new governor and the new legislature will have to find the money to refund. So it's an important issue. It's an important issue in the short term. It's an important issue in the long term. And I think it's an important part of state constitutional law. I don't know how the lawsuit will turn out. The legislature will be represented by probably by Butch Spear, who you know. Butch is the clerk of the House. He's an extraordinarily capable lawyer, very good lawyer. And the business community could lose. I'm not here to predict the outcome of the legislation. I am here to tell you, in one person's opinion, what I think the state constitution says and what I think it means. If you know, state constitutions aren't enacted in a vacuum. If you go out to the LSU library, you will find 14 volumes of records from the Constitutional Convention of 1973. The convention met a little over a year. They met at the old White House Inn down here. It was torn down. I think the Division of Administration building is there now. For a solid year and a few weeks, the delegates who were elected by the people met. They met sometimes they went well into the evening. The only time they couldn't meet in the evening was Thursday night. They had to leave because there was wrestling on Thursday night. But other than that, they met for a year drafting the Constitution, and all those documents are preserved. There are verbatim debates of the full convention on the floor of the Constitutional Convention. You can go look at what the committees discussed when they were putting together the proposals to be debated by the full Constitutional Convention. So not only do you find the verbatim debates on the floor of the convention, you find the proposals considered in the various committees, you find the committee notes from the various committees, you find the staff reports from the various committees. It's a treasure trove, if you care about state constitutional law, of information about what the delegates, the drafters of the Constitution, but equally important, what the voters, the ratifiers of the Constitution intended. And I think if you look at those records, as I have, some of you know I teach state constitutional law at LSU. That doesn't mean I'm an expert. I don't pretend to be. It doesn't mean I've read the Constitution and a lot of the Constitutional Convention records. And if you go back and look at those records, not just look at the plain language of the Constitution, which I think is pretty clear, but if you go back and look at those records, I think what you'll see is that the delegates, and you have to assume the voters, understood the importance of a two-thirds vote and clearly intended there be a two-thirds vote requirement on using their language on all tax matters, end quote. That wasn't something the delegates just came up with. There was policy behind that. I mean, if you look, I'll quote you from one of the staff reports for the Committee on Revenue, Finance, and Taxation, which came up with the language from Article 2, Section 7. This is what the staff report says. This is from the research staff. Lee Hargrave, former chair professor at LSU, was in charge of the staff. I'll quote from it. The greatest advantage of the two-thirds rule is in preventing the legislature from enacting tax laws which would place too much of a tax burden on the taxpayer. Accordingly, the two-thirds rule prevents the legislature from passing tax laws too hastily and without serious consideration. You will also find in those records a statement from the Public Affairs Research Council, which I'll share with you. This was the statement that PAR submitted to the record. I'll quote it briefly. The requirement of 2/3 of the elected membership of both houses to pass tax laws should be continued, as should the 2/3 requirement for the issuance of bonds, addressing persons out of office, and impeaching the governor, creating educational or charitable institutions, passing constitutional amendments, and a host of other unusually significant decisions the legislature is called upon to make. Again, these are Parler's words, not mine. Supermajorities of 2/3, 3/4, or other varieties are widely used throughout all levels of government in America. They are used not only in legislative decision-making, but they're used widely in jury decision-making. The supermajority is normally used to assure that in grave matters a substantial consensus is reached rather than half the people plus one. Supermajorities thus provide a semblance of stability. That's the policy behind the 2/3 vote. The idea that raising taxes, no matter what you call them, taking money out of people's pocket, is something that government needs to think through carefully. It shouldn't be done hastily. If you're going to do it, there ought to be deep and broad support. And again, I think if you look at the Constitutional Convention records, I mean, I just made a quick list. You can see it from some of the various documents. If you look at the comments to Article 7, Section 2 as it came out of committee, if you look at the staff reports, if you look at the verbatim transcripts, you will see that the delegates, when they were referring to Article 7, Section 2, intended it to include, their words not mine, quote, all tax matters. Now, I know there's some disagreement on that by some members of the legislature. They're relying on, I believe it's a 1993 Attorney General's opinion, which I've read. Many of you probably have too. To me, it's not on point because it deals with suspending a law. And while it's true that HCRS, the subject of the litigation, had to do with suspending the legislature only raised taxes in one instance by suspending the law. In the other cases, they just passed the statute. I suppose the argument of the lawyers for the legislature will be that that the law is not clear, that it's uncertain. I disagree with that, obviously. They may argue, if you look at the language of Article 7, Section 2, it refers to new taxes, increases in existing taxes, and a repeal of an existing tax exemption. Well, the legislature not only reduced some tax exemptions, but they addressed deductions, they addressed rebates, and they addressed credits. So I suppose the argument will be, well, the Constitution doesn't say anything about the deductions and credits and exemptions, therefore the legislature can do it. And there's some credibility to that argument. I mean, I don't mean to sound too wonky here, but Louisiana's Constitution is different from the U.S. Constitution. The U.S. Constitution is based on delegated powers. If Congress does something and you challenge it, Congress, to defend itself, has to prove that there's a specific provision in the U.S. Constitution that says it has authority to do that. If Congress can't point to a provision of the U.S. Constitution that says it has the authority to do it, it can't do it. The Louisiana Constitution is completely different. The Louisiana Constitution is a constitution of plenary power. That means that the legislature can do anything it wants to do, anything, unless somebody challenging the act of the Constitution can point to a specific provision in the Constitution that says the legislature can't do it. You see the difference? Huge difference. That's why any act passed by the legislature is presumed to be constitutional. So the burden to overturn a statute passed by the legislature is heavy, as it should be. But the legislature has enormous power. Now, the legislature has ceded most of that power to the governor, as you know, but that's a topic for another day. So I'm well aware of the arguments, and they're good ones. But I still believe that the language supports the two-thirds vote requirement, and more than that, the policy does. If you look at a number of cases, a case, I'll be glad to give you the citations if you're interested, a case called Bessie v. Nix, decided by the Louisiana Supreme Court in 1977. Another case, a very famous case, decided in 1993 dealing with forced heirship called Succession of Lauda. You will see that the Supreme Court, in interpreting a provision of the Louisiana Constitution, doesn't only look at the language. Obviously, the language is important. And I think the language in this instance supports the two-thirds vote requirement. But the legislature, or rather the court, also says you're supposed to look at the Constitutional Convention records, which I talked about as well. But there's one more thing that the Supreme Court says we're supposed to do. You've heard this debate about being a strict constructionist. Strict constructionist doesn't mean you just read the language and whatever the language means to you is what the law is. A strict constructionist also is going to look at the policy behind the language. Let me read you a quote. Again, I'm sorry to sound so wonky, but this is important. This is a quote from How You Ought to Interpret the Constitution. Justice Dennis wrote this quote in a famous opinion called Succession of Lauda. Quote, "In construing a constitutional provision, the courts may consider the object to be accomplished by its adoption, and the evils, if any, sought to be prevented or remedied in light of the history of the times and the conditions and circumstances under which the provision was framed." In other words, why did the delegates put it there? Why did the delegates require a two-thirds vote? And I think the records and the policy are both clear. They required a two-thirds vote on, quote, all tax matters, end quote, their words, not mine, because they wanted the legislature to have a deep and broad consensus before raising taxes. Now, you may agree with that. You may disagree with that. But if you believe, as I do, in the rule of law, and I know you do, then I think if you don't like what the Constitution says, you need to change it. Let me give you one last example of what I'm talking about here. I hope I'm being clear. You can't just rely on the words of the Constitution. That's the point I'm trying to make. You've got to look at the policy, you've got to look at the debates, you've got to look at the committee records to see what's behind it. Let me give you an example. There's a famous case in Texas. Called Director of Agriculture and Environment versus Printing Industries Association of Texas. It's a 1980 case. It dealt with the Texas Constitution. Texas used to have a provision in its Constitution that said all printing contracts have to go to the low bidder. All printing contracts in Texas had to go to the low bidder. Well, the Texas Department of Agriculture and Environment decided it could save money by doing the printing in-house. Well, you know what happened. The printers who had the business didn't like that much. So they filed suit. Said, you can't do it. It's unconstitutional. Here it is in the Constitution, big as Dallas. All printing contracts have to go to the low bidder. Clearly, the drafters of the Constitution intended the private sector to do the work. You don't have a low bidder if you do it in-house. Pretty good argument based on plain language. But then the Texas Supreme Court looked at the policy behind it. They looked at the records from the convention. And clearly the policy was not to choose between the private sector and the public sector. The policy behind the provision was to prevent corruption, prevent a politician from hiring his buddy who was in the printing business. So the Texas Supreme Court ruled, perhaps predictably, but at least in my opinion, accurately, that the decision to do the printing in-house was constitutional. Again, I don't know how this legislation will, or rather this litigation will come out. The legislature is very well represented. They may win. I predict if they do win, it'll be on technicality because somehow the courts decide the language is unclear. I think it's very clear, but I will tell you this. If the legislature does win on this one, I think you will see a constitutional provision proposed at the next legislative session to make clear in the state constitution what I believe is already clear. It's been the law in Louisiana for 100 years. It's in the 1974 Constitution. It was in the 1921 Constitution. It's clear from the debates, the committee records, the comments of the committee records, the research reports. A 2/3 vote is required for all tax matters. And there's a reason for that. There's a reason for that. The voters have said categorically and unequivocally, in my opinion, that they want there to be deep and broad support in the legislature before taxes are raised. We've got some time for questions. I do want to hit a lick on one other subject. It's not one that Michael talked about, but it came up in the news recently. I saw where Commissioner Fannin says that the budget next year is likely to be about a $700 million deficit. We just finished our rating calls with the rating agencies. They were successful in my opinion. I asked that they not downgrade Louisiana. I wasn't quite as ambitious as Commissioner Nichols, who wanted an upgrade. I would have been delighted to have an upgrade, but the rating agencies don't quite believe in the Louisiana miracle. We didn't get a downgrade, and I consider that successful. I'm very pleased. We argued, at least I did, that the new legislature and the new governor and the new treasurer and the new statewide officials should have an opportunity to get this car out of the ditch. All 4 wheels were in the ditch. We got 1 wheel out in the legislative session, but we still got 3 wheels in, and the new leadership deserves a chance to be able to get the car completely out. The subject that came up, one of the subjects that came up, had to do with mid-year budget cuts. And this is what I told them. I told them, look, our budget is balanced for now. Okay? No one can rule out the possibility of mid-year budget cuts. There's some things we have to watch out for. Obviously, the price of oil. We have budgeted $62 oil. Well, it's not trading at $62 today. Before I came over, it's about 42 and change. So obviously, we could have a revenue gap there. We could also have a gap caused by spending. The division administration and the governor have put in about $222 million in the budget of, quote, efficiencies. In other words, there's a line item that says, it's actually several line items. They say we're going to save $222 million this year throughout state government through efficiencies. And you ask them, well, what do you mean by efficiencies? And they say, well, just trust us. Well, we've been down this rabbit trail before, where 2 years ago, I think, actually 2012, they did the same thing to balance the budget, and the efficiencies did not come to pass. So obviously, we have to watch those $222 million worth of efficiencies and make sure that they do come to pass. We also have some one-time money in the budget, which we were very frank with the rating agencies about. We've got about $542 million in non-recurring revenue. That's the usual suspects. You've heard them before. Tax amnesty proceeds, fund sweeps. They used a bond premium to balance the budget. Hurricane disaster monies. They used debt defeasance, where you take one-time money and make your debt payment for 1 year. That's about $542 million. The biggest risk we're going to have that we've got to watch is our spending at the Department of Health and Hospitals. The DHH has said pretty clearly, I think, during the legislative session, and I believe they say the same thing now, that the amount appropriated to them is going to be short about $338 million from the money they're going to need. DHH says they need another $237 million for Bayou Health, another $60 million for community-based waivers, another $16 million for Medicaid prescription drug payments for our dual eligibles, and another $9.1 million from long-term personal care services, and there's one more I can't remember. So that's $338 million. So if you add that $338 million and the $222 million and the $62 oil, you can see that it's possible we'll have mid-year budget cuts. I'm not predicting them, and I'm certainly not hoping for them. But I told this to the rate agencies. They knew it anyway. Their analysts was filed on Louisiana. They know as much about our budget as we do. But as I told them, look, it's not like we don't have experience with mid-year budget cuts. Okay, we've had 6 since 2010. If we have them, we'll deal with them. But hopefully we won't have them. Last thing I want to talk about, and I've got till 1 o'clock.
Yeah, we want questions, sir.
This will be my last comment. This is something I hadn't planned on talking about, but I think it's important. I don't need to tell you about the state's finances. We need to be real careful in the last few months when there's a change in administration. I've been through this before, and many of you have too. It's kind of the last few days of the legislative session. You've got to be especially vigilant in those last few days. We have an extraordinary building in New Orleans that, in my opinion, I know some of you disagree with me, but in my opinion, would have saved taxpayers about $500 million and would have been up and functioning a year ago as a university hospital. But that's the old big charity building. I lost that fight. We're in a new building, $1.2 billion. We're going to make it work. We've got to. We don't have a choice. We just spent $1.1 billion in taxpayer money. But the argument was made at the time that we have to have a new hospital because the old charity building, it's just you can't go in it. You'll die. You'll get diseases, and it's tumbling down, and it's no good for anything. Well, all of a sudden, of course, we find out that's not the case. The administration wants to sell it to the private sector so they can build apartments. We need to be real careful here, folks. There's not a lot of transparency in this process. The governor and the commissioner have unilaterally decided they wanted to see proposals. There are 4 proposals from the private sector. They were not shared with the taxpayers, the public, or the press. The press had to go file a public records document request to get copies of them. That's a very valuable asset. As best I can tell from looking at the proposals, the biggest price offered the state is $30 million. The developers are also requesting a ton of tax breaks to develop the building. Well, all I'm saying is, A, we've got to do something with Big Charity. It's a beautiful Art Deco building. We should do something. I wish we had a hospital in it, but we don't. We've got to do something. It's very valuable, and this is a decision that ought to be made involving the new legislature and the new governor. I don't want to see this administration do this, make a deal with somebody in the private sector going out the door. It's too important. I'm not suggesting it would be a bad deal. I'm just suggesting that Sunlight's a pretty good antiseptic, and I would respectfully, and I will be sending a letter to the governor asking that he please slow this train down and let the new governor and the new legislature be involved through a public meeting in deciding what's the best use for New Orleans and the Louisiana taxpayer of that new building. And I think that's very important. That's all I have. I'll be glad to answer any questions you have. Yes, sir.
John, another thing with the 2/3 vote on the revenue measures is there is a House rule that says at a certain point in the session, all votes have to be by 2/3 majority.
Right.
How do they justify vote? Or do you have any idea?
That's one I can't answer. Look, I think what happened here, and I think it's clear. The legislature couldn't get a 2/3 vote. So they just decided to give a legal opinion that it only takes a majority vote. And they based it on an Attorney General's opinion, an old Attorney General's opinion. And I have great respect for the current and past Attorneys General. But an Attorney General opinion is just that, it's an opinion, it's not a court judgment. And we know how this process works. The legislature, when it gets in a jam and needs an opinion, it goes to the Attorney General, says we need an opinion. And by the way, we vote on your budget. Okay, I mean, we know how it works. I'm not saying we shouldn't pay attention to Attorney General opinions, but we don't do this in a vacuum. It's part of the political process. I just think it's clear. I understand, I don't agree, I understand why they did it, but I think it is clear, and it's been clear for 100 years, that to raise taxes, you have to have a 2/3 vote. Just like to pass a constitutional amendment, you have to have a 2/3 vote. That's the rule of law. I believe in it. If you don't like the law, change it. But don't just ignore it. I remember back in the early 90s, I'll tell you, and I've seen this happen before, the early 90s, I was out of government. It was involuntarily retired for a while, but Governor Edwards was governor, and they needed money, and so they passed a law that said that we're going to raise taxes on corporate and income and franchise taxes on corporations, but only out-of-state corporations have to pay it, not Louisiana corporations. Well, God, I've never seen one that violated both the state and the federal constitution at the same time. They violated the state constitution because they did it in the wrong year, and they violated the federal constitution under the Federal Commerce Clause. They knew it was unconstitutional. They knew it was going to get struck down, and it did. So but they needed the money. But that didn't mean it's the right approach.
John, when you're talking about tax...
I get you.
Oh, I'm sorry.
No, you go ahead.
I don't recall at the Constitutional Convention any conversation about tax credits. So I do recall 2/3 and increasing taxes.
Right.
So is it your position that tax credits should have been passed with a 2/3 vote?
The Constitution refers to all, or the records of the Constitution refer to all tax matters, yes.
But so currently, do you have to have a 2/3 vote to give a tax credit?
I'm not sure. It depends on what the legislature decides. I'm just telling you what I think the Constitution says.
So should they be requiring every time they give a tax credit a 2/3
I
vote?
think that all tax matters means all tax matters.
So looking back, I don't think they've been doing 2/3 vote.
I'll take your word for it. Robert?
You mentioned that Butch Beer would probably be defending the legislature, and in fact, he has. The two responses that I've seen so far to the litigation, the Tourism Department has asked for an extension of time to file an answer.
Right.
Mr. Spear filed a peremptory exception of no cause of action, but there was no order page to set the matter for hearing. Given that it is a veteran attorney who's well-versed, do you think that's just a stall mechanism to let the process go further, or why do you think there was no I mean, normally that's just...
When I practice law, it's been a while, but I've filed exceptions like myself. It's a tactical maneuver. Butch is a great lawyer, okay, and he's a good constitutional lawyer, and I'll be the first to say that he can win this thing. But I think if he does, it'll be on a technicality, and it will be on the argument that the Constitution's not clear, something alongside what Beth's talking about. And this is just my personal opinion. I think if you look at the records, look at all 14 volumes of them, look at the 21 Constitution and the 7-4 Constitution, I think it is clear. And all tax matters means all tax matters. That's just my opinion.
Could I have a quick follow-up then? You mentioned a moment ago about DHH spending, and when you were here last time, you talked about 900,000 in 1 year visits to the emergency room for non-emergency care. Could you care to elaborate as to why that seems to garner so little attention to put a spotlight on those facts versus the inherent proclivity to say, let's raise more money, let's raise more money? Could you just comment on why you think some of the points you're making don't seem to be getting a whole lot of attention?
Well, controlling costs while still being able to deliver a decent product is hard work. I mean, it's not as easy as just walking in and raising taxes and fees. It's hard work. And the governor's not here. He's good, but he's not that good to be able to do it when he's in another state. it's hard work. I just watched what other states have done and done successfully, and it's clear to me that those states that are doing something to control their costs of the Medicaid program are doing it in part through controlling the abuse of the emergency room. It doesn't mean these folks are going to go without care, but you can give a pregnancy test a lot cheaper in a private clinic than you can in an ER. You know, I probably told you all this last time, but I don't remember his name, but I got a call one time from an emergency room physician in New Orleans. He read something I wrote. He said, "Kennedy, you're right." He said, stop me if I told you this before, but he said, you know, we've got a lady, an elderly lady, sweet as she can be. She comes to our emergency room every Saturday night. And I said, well, why? She gets sick every Saturday? He said, no. She lives with her kids. Her kids don't want to pay for a babysitter. So they drop her here every Saturday night. And we got to give her a physical and talk to her. We have a good time. And then I send the bill to Medicaid for a couple $1,000s, and they pay it. Now, how much sense does that make? And you know what DHH is doing about it? Nothing. That's just my opinion.
Thank you, Treasurer.
Yeah, Mike.
Just fact check a little bit. The governor during the undercard debate was talking about cutting the budget 26%. Fact check, if you would. 26% of what? Was that federal money? Was that state money? What are we talking about?
If you compare apples to apples, the current budget today is $25 billion. We have no more hurricane money in it. It's gone. Go back to the last budget we had that had no hurricane in it, no money in it. That was the 2004-2005 budget. It was $16.5 billion. We got in all this federal hurricane money, but we were just a conduit. We were just a conduit. It passed through us to our people. It was non-recurring money for which we were conduit. So I think that's what the governor's talking about. I think the other thing he's talking about, as you know, many have said, including the governor, we took no federal stimulus money. That's nonsense. The governor took about $3 billion of stimulus money, put it in the operating account, and then he spent it. Now, I guess that might be what he's talking about, that he cut it. He didn't cut it, he spent it. But if you compare the 2004 budget today to the budget today, we went from $16.5 billion, no hurricane money, to $25 billion, no hurricane money. That's a 50% increase. The general fund went up between 30 and 35%. That's over a period of time when we've lost people, we lost the congressional seat, and inflation's been under 2%. Those are the numbers. And it does bother me when the governor says that. It offends me because those aren't the numbers. The governor's done many good things, but finances is not one of them. And I think that, we all know the governor used the state as a stepping stone. And boy, did we get stepped on. Yeah, man.
Could you drill down a bit on the charity sale? Is that something that they feel is going to be expedited quickly? I don't know what the time frame of it might be, but they've unloaded assets pretty quickly in this administration.
Yeah.
So what is the time frame?
Nobody knows, Lanny, and that's one of the things that bothers me. Commissioner Nichols, presumably with the governor's permission, just went out, did an RFP. The proposals came in, they're secret. The press had to file a public records document to get copies. I'm afraid the governor and the commissioner on their way out the door are going to take the position, which I think is erroneous, that they have unfettered discretion to do whatever they want to with a state asset, and therefore they're going to sell that building. I don't think that's...
Do they legally have money?
I don't think so, but that's never stopped them before. And I think that would be a huge mistake. If I'm wrong about this, I will apologize. But we've seen it happen before. Now that asset is going to... We just built $1.1 billion new hospital right down the street. Once it's up and going, the old charity building is going to become a lot more valuable. This is the worst time to be able to sell it. And you also, if you look at the proposals, I can't get an actual copy of the proposal. I just know what I read in the media. I have less luck with a public record document request than y'all do. But if you look at the reports, the most any one of those developers is offering is $30 million. The rest of them want us to put up money. Okay? All I'm saying is slow this thing down. They ought to slow it down anyway, because if they try to do this on the way out the door, I don't know who the next governor's going to be, but I guarantee you, he's going to say, whoa, I didn't sign off on this.
Would the budget committee have to approve that?
Don't know.
I'll say all.
But the budget committee doesn't have a real good record of slowing them down in the past. I mean, I don't mean to be rude, but this is a big deal. That's a very valuable building. And we were lied to when they told us that it can't be used again. So obviously, I mean, when you deal with an asset of that size, it's hugely important to New Orleans. It's hugely important to the taxpayers. And I just don't like the feel of the way this thing's going.
Let's make this last question.
Come on.
Same, following up on Lane's question though, are you assuming they're trying to rush it because they're afraid there are some budget cuts on the horizon and they need the money? Otherwise, I'm not really sure I get what this means.
Well, you know, Melinda, I don't know, and I don't mean, I'm not trying to insult them. I'm just describing them. I mean, if you look at their track record, and I see this going on, and I know the commissioner and the governor have taken their position in the past that they don't need the legislature's authority. They privatized our entire healthcare delivery system. Now, they went to the legislature after the fact, but made it very clear they didn't have a choice, and I just think we need to slow down here. Can I hit a lick, Michael, on one more thing that's important? And I've watched, we all see the crime figures in New Orleans. Murders up 30% in the first half of the year, and those are the ones that are reported. And I know we have crime in other places, but clearly it's a problem in New Orleans. I feel very strongly about this. There's been a debate going on about the governor and his out-of-state travel and his using the state police. Look, there are a lot of nuts in the world, and governors need protection, okay? They have to have protection. Their families have to have protection. But normally governors travel out of state maybe once a month, if that. I think if the governor, he's running for president, I think he's got $10 million in his accounts. I think what he really should seriously consider doing is paying for his own security out of state and let us take those troopers and send them to New Orleans. When we sent troopers to the French Quarter, crime dropped 40%. I'd also suggest, I know the lieutenant governor's been very critical of the governor. Frankly, I think the lieutenant governor ought to give up his troopers too. Lieutenant governor doesn't need protection. From what? I mean, he's the only statewide elected official other than the governor. I think it becomes a vanity thing, and I think we all ought to sacrifice it this time, because those troopers make a difference wherever you put them in New Orleans. And if you can just save 5 or 6 of them and put them in New Orleans, we can at least make a dent in the crime. That's it, I'm done. Thanks, y'all. Have a good week.